This podcast is brought to you by Bloomberg Law. For more information about our professional services for the legal industry, please call 212-617-6569.
This is the Bloomberg Law Podcast. I'm Josh Block. The issue of political campaigns using popular songs without permission seems to come up every election cycle. This one is no different. Newt Gingrich is being sued for using Survivor's Eye of the Tiger. And Kanon has asked Mitt Romney to stop using his Wavin Flag. I'm joined now by Lawrence Iser. He represented both Jackson Browne in his lawsuit against John McCain and David Byrne in his lawsuit against Florida Governor Charlie Crist. That one famously ended in Crist publicly apologizing via a YouTube video. Mr. Iser, Mitt Romney had licensed the song that he used, Kanon's Wavin Flag. Does a politician or a campaign have to get the permission of the artist or songwriter in order to use the song?
Well, Josh, it depends on what the use is. So when Romney's campaign says they licensed Wavin Flag by Kanon, I think what they're referring to is they have a blanket or a traveling license from ASCAP to utilize that song and anything else in the ASCAP catalog at a live campaign event. But if they try to use Wavin Flag in a commercial, then they do need to have specific licenses in place. I think the most famous example that we can think of is back in 2008 when the Republican campaign at its convention brought Sarah Palin on stage by using the song Barracuda by Heart. And there was a big hue and cry about that because Nancy Wilson claimed that she didn't give permission for that. And in fact, that use fell within the so-called public performance license. It was a use at a public gathering. It was a live use of the song, if you will. And they're protected, if they have the copyright license in place from ASCAP, from a claim for use of the song at that live event.
The notion here that they've got a license, but the artist is upset, there isn't necessarily a lawsuit there, or there isn't a claim, is there?
If there's a false implication of some connection between the artist and the politician, or an implied endorsement by somebody who's famously associated by the song, and if that occurs, then aside and apart from copyright, there's also a claim that can be made under the Lanham Act, which is the United States Trademark Act, for that false implied endorsement, if you will. And there's also another set of laws called right of publicity, where the use of a famous persona, in this case it would be the famous voice of a musical artist in connection with the campaign, also gives rise to a claim under the right of publicity.
In the case of Mitt Romney, in this instance, if Kanon was just upset with the song being played at the rally and they had gotten the correct licensing from ASCAP and BMI, then there wouldn't be a suit there.
Probably not. No one has litigated yet the issue of, in the instance where you have the license from ASCAP, but the artist complains about the affiliation, does the artist have that separate claim based on the use of the live performance and his persona at the live performance?
In the cases that you brought, and in most of these cases, the politicians tend to back down and apologize before the case goes to trial. There's some settlement. And since we haven't really gotten guidance from the courts, do you have a sense of how that would go?
If the artist is famous enough, and if a request to not use the song is ignored, and there's a persistent use of the song, let's say the way Newt Gingrich has continued to use Eye of the Tiger for a while, even after the initial complaint. But I do believe that somebody famously associated with that song would have the right to sue for the implied endorsement under the Lanham Act, and perhaps for a violation of the right of publicity.
How did the cases that you brought for Jackson Browne and for David Byrne end? What was the settlement? And tell me about the Crist apology on YouTube that was so important to David Byrne.
Each of the cases settled. They settled at different points in the case. In the case of Jackson Browne, when we filed the lawsuit, the defendants were the Ohio Republican Party, McCain himself, as well as his campaign and the Republican National Committee, they hired a slew of lawyers who brought many, many different motions to dismiss, challenging the legal basis for our lawsuit. And when all of those motions were denied, then they came to us, and we were able to reach a settlement. The terms of the settlement, the financial terms, have always remained confidential. But what was important to Jackson was to make sure that there was a public acknowledgement, and most important, it was a pledge that in future elections, the Republicans would respect artists' rights and obtain licenses as appropriate for copyrighted works. And so we were a bit surprised when less than a year later, in 2010, we ran into the same situation where Charlie Crist, then running for the Republican nomination for governor, used a Talking Heads song written by David Byrne, Road to Nowhere, in an attack ad against Marco Rubio. Virtually the same kind of situation. They did not clear the rights to use the song in the campaign ad. And after a period of time where we tried to resolve things quietly and could not do it, they really left us with no choice but to file suit. So we did, and they asked us to come down to Tampa for a mediation, so that we met with the governor, and we were able to work out a settlement. One thing that David Byrne insisted on is that since they had taken his song and his voice and his persona and put it on YouTube, he insisted that Governor Crist give an apology that would also be broadcast on YouTube, and it's kind of fun to watch.
Hi, I'm Charlie Crist. During 2010, I ran for a seat in the United States Senate. During that campaign, a video advertisement utilized a song made famous by David Byrne and the Talking Heads called Road to Nowhere. Regrettably, the campaign did not ask permission to obtain a license from Mr. Byrne to use Road to Nowhere in the advertisement.
In the current case against Newt Gingrich, Frankie Sullivan, one of the authors of Eye of the Tiger, he says that his motives have nothing to do with politics. He says that his song could lose value if it becomes entwined in the public's mind with a politician. Is that an argument that you would pursue in court?
I think, first of all, in none of these cases that I'm aware of has it been about politics. When people write about it, particularly people with the Republican leanings, they always say, oh, this is political, and they try to make it look as if the politicians are victimized by liberal-leaning songwriters. When the truth is, just as Frankie Sullivan says, nobody asked him. Nobody came to Frankie, nobody came to Jackson Browne or David Byrne and said, hey, we would like to use your song as part of our political campaign or as part of a commercial. So the suggestion that they were being victimized by these guys is just not true. What is taken away from the songwriter and the artist when this song or the sound recording is just used is the right to choose who they want to affiliate with, if anybody.
Not always, but most of the time, this is an issue with Republican candidates. There is a notion that these cases are good for Republican candidates. It's perverse, but it brings the candidate attention and often to the candidate's base. It's not considered negative attention. That said, would you ever counsel one of your clients to hold off on filing a suit like this?
I can't talk to you about what I would or would not recommend to a client. I don't think that being branded as a copyright infringer helps anybody. I think just the opposite is true, and I think people will say that, and undoubtedly a lot of attention is paid when a famous songwriter like Jackson Browne or David Byrne or Frankie, in this case with Newt Gingrich, file suit. But I have to say that somebody who wants to be president of the United States and hopes to someday raise his or her right hand and swear to protect and defend the Constitution, they need to know and they need to acknowledge that copyright protection itself comes from the Constitution. It's found in Article 1, Section 8. It seems to me if somebody wants to be president, they need to be respecting the Constitution, and a very good place to start is in their own political campaign and making sure their house is in order.
Your Jackson Browne and David Byrne cases have been called a turning point, and Mitt Romney actually asked and got permission from Kid Rock to use one of his songs. But still, this issue is alive and well, and it keeps happening. So what do you make of that, and do you think it will end, or is this just part of political campaigning?
I was really excited in December when I read that Romney had gone to Kid Rock. and had asked permission and had obtained permission. And Kidd's response to that was really interesting to me. He's saying, I'm not endorsing Romney, but I am saying this. Anybody who runs for president is doing something important for the country. So anybody who wants to run for president, feel free to use any of my songs. I think it's great. And the situation, which I really liked, is that he was actually asked. So people assume that songwriters and artists are going to say no. But it may just be the mentality of Kid Rock, which is, I think most people think that if you run for president, you are trying to do something important. But the problem we've had is so often the politicians are in such a hurry and their campaigns are moving so quickly, they don't bother to ask. And so, the long answer to your question is, yeah, I think we're going to continue to see it. And look, what better example of that is that a month after Mitt Romney asked permission from Kid Rock, he started using this Wavin Flag by Kanan without asking permission from him, although he probably did have the correct license from ASCAP. I think there's something about running for president that means that people cut corners and they don't get the right permissions and they don't get the licenses.
That's attorney Lawrence Iser. You can find more of our podcasts on Bloomberg Law's YouTube channel. Thank you for listening.
Copyright 2012 Bloomberg Finance LP, all rights reserved. The views expressed herein are those of the speakers and not of Bloomberg Finance LP. These discussions are for informational purposes only and should not be construed as legal advice, which has to be addressed to particular facts and circumstances involved in any given situation. Bloomberg Finance LP and its affiliated entities do not take any responsibility for the content contained herein and do not make any representation or warranty as to its completeness or accuracy.